37-year-old woman was shot and killed by a federal agent this week. She was a U.S. citizen, and she was not the target of any investigation or arrest. So what happens now? I'm going to do my best to strip this down to the law, not the politics. What we know so far, according to local officials, is that the victim, Renee, was a legal observer monitoring federal activity in Minneapolis. She was not the subject of any immigration enforcement. Federal officials assert that she used her vehicle as a weapon and attempted to run officers over. State and local officials say the video evidence contradicts that account. The facts are disputed, the investigation is ongoing, and the political discussion on social media is sharply divided. But the legal framework for analyzing the shooting is clear. Anytime there is a shooting involving federal agents, the questions are the same. Was deadly force justified under the circumstances? Was there an objectively reasonable threat of death or serious bodily injury? And would another reasonable officer in the same position have done the same thing? That analysis does not change just because the officer works for ICE. Federal agents are bound by the same constitutional standards governing use of force. If the facts support a lawful use of force, there is no crime. If they don't, then criminal exposure exists, although prosecutions of federal agents are rare and heavily dependent on the facts and evidence. The civil side is where most of these cases eventually live. When someone is killed by a federal officer, families generally ask a simple question: who can we sue? Most people assume a wrongful death lawsuit is straightforward. When federal officers are involved, it is not. In many cases, the courthouse door is already partially closed. There are two primary legal pathways, and they work very differently. First is the Federal Tort Claims Act, the FTCA. The FTCA allows lawsuits against the United States itself for negligence committed by federal employees acting within the scope of their duties. This looks like traditional personal injury law: negligence, causation, and damages. But there's a major limitation. The FTCA does not allow constitutional claims like excessive force. It only covers torts, not rights. It also comes with procedural hurdles, administrative exhaustion, and strict deadlines. You miss one step, and the case never gets heard. The second type of case is a Bivens claim. A Bivens action is a lawsuit against the individual federal officer personally for the constitutional violations, most often excessive force under the Fourth Amendment. But here's the problem. The Supreme Court has been steadily narrowing Bivens claims for years. In 2022, it decided Egbert v. Boulay, a case involving a Border Patrol agent. The court refused to extend Bivens and made a clear distinction that courts should not create new remedies in immigration or national security context. That matters here. Immigration enforcement is one of the areas where courts are most likely to say no new Bivens remedy exists. And even if a Bivens claim survives that hurdle, the officer can still assert qualified immunity, which shields officials unless they violated clearly established law. That's two separate barriers before you even reach the merits of the case. So where does that leave the families? In many cases, they're pushed into a narrow FTCA negligence claim against the government while being blocked from suing that individual officer directly. That's not intuitive. It's not emotionally satisfying, but it's the legal reality. The criminal question is about justification. The civil question is about access to courts. Right now, the law heavily favors the badge over the family. That may not feel fair, but that's the legal framework. The facts are still developing, and if they change, this analysis may shift, but the legal structure does not. That's how you analyze this case the right way.